Welcome to WeLearn Virtual Learning Network. This is session number 8 of Indian Partnership Act. Topics to be covered are introduction of partnership, meaning of partner, firm and firm name, maximum limit on number of partners, essentials element of partnership, meaning of mutual agency, real test of partnership according to section 6, kinds of partnership and partnership deed, and lastly advantage and disadvantages of partnership firm. Introduction. The law of partnership is contained in the Indian Partnership Act 1932, which came into force on 1st October 1932. A contract of partnership is a special contract where the Partnership Act is silent on any point. The general principle of the law of contract apply. This is according to section 3. This act extends to whole of India except the state of Jammu and Kashmir. It means partnership in India are governed by the Indian Partnership Act 1932. Partnership is formed as a result of an agreement between two or more persons who have agreed to share the profit of a business carried on by all or any of them acting for all. The general principle of law of contract and agency also apply to partnership except where the act specifically provide to the contrary. Meaning and definition of partnership. In section 4, para 1 of the Indian Partnership Act 1932 defines partnership as partnership is a relation between persons who have agreed to share the profit of a business carried on by all or any of them acting for all. So partnership is the name of a legal relationship between or among persons who have entered into a contract. So this definition clearly indicates some characteristics of partnership. First one is it is association of two or more persons. It must arise out of an agreement. Agreement must be carried on a business. Agreement must be to share the profits of the business. And last one is the business must be carried on by all or any of them acting for all. Meaning of partner, firm and firm name. Section 4 of Indian Partnership Act 1932 provides that person who have agreed into partnership, जो person partnership पे agree करते हैं with one another are called individually partners and collectively firms. वो individually partners भी कहलाते हैं या collectively firm भी कहलाते हैं. And the name under which their business is carried on is called firm name. Partnership is just invisibility which binds the partners together. Partnership एक invisible contract है जो कि bind करता है दो partners को आपस में and firm is the visible form of those partners. और firm एक visible है उन partners की who are thus bound together, जो उन दोनों को partners को आपस में bound करता है एक दूसरे के साथ. Maximum limit on number of partners. According to section 11 of Companies Act provides that the maximum number of persons a firm can have. In case of partnership, firm carry on a banking business. 10. In case of partnership, firm carry on any other business. 20. If the number of partner exceed the aforesaid limit, the partnership becomes an illegal association. अगर रूल्स के अकॉर्डिंग आपने पार्टनरशिप में मैक्सिमम नंबर्स उतने नहीं रखे जितने कि उसमें बताए गए हैं, देन आपकी पार्टनरशिप इलीगल मानी जाएगी. Essential elements of a partnership. First one is two or more persons. Second, an agreement. Third is sharing of profit. Fourth one is business, and last one is mutually agent. Two or more person. There should be at least two persons to form a partnership. If the number of partners get reduced to one by any reason, say death or insolvency of partner, it would cease to be a partnership. As for the maximum number of partners in the firm, the Partnership Act is silent. However, according to section 11 of Indian Companies Act, limits the maximum number of partners to 10 in case of a banking business and 20 in case of any other business. If the number exceeds this limit, this partnership becomes an illegal association. In any partnership firm, the number of partners should not exceed 20, and if it carries on a banking business, it should not exceed 10. An agreement. A partnership originates from an agreement between persons. This agreement may be expressed or implied. Expressed means written or oral. It should also be noted that a partnership does not arise out of status, as in the case of joint Hindu family, or by operation of law, as in the case of co-ownership. It is essentially the creation of a contract between two or more persons, and all elements of a valid contract must be present. Sharing of profit. Sharing the profit of business is the essence of partnership unless otherwise agreed. Sharing of profit of a business implies sharing of its losses as well. A person can become a partner on the understanding that he will not share the losses. The ratio in which the profit and losses will be shared is a matter of agreement amongst the partners. It should be noted that sharing of profit of a business is essential. So, it does not follow that everyone who participates in profit of a business is necessarily a partner. Business. It means business carried on by all or any of them acting for all. The underlying principle which governs partnership is the agency relationship amongst the partners. The business of the firm may be carried on by all the partners or by any of them acting for all. This means that a partner is both an agent and a principal. He can by his act bind the other partners and is bound by the acts of the other partners. Thus, the partners have relationship of mutual agency between them. This is according to the last point, mutual agency, that they have mutual agency between them, and law of partnership is regarded as an extension of general law of agency. Real test of partnership. This is according to section 6. The true test of partnership is the existence of mutual agency relationship, that is the capacity of the partner to bind other partner by his acts done in firm's name and be bound by the acts of other partner. Sharing of profit is an essential element of partnership, but it is not a conclusive proof of partnership. Sharing of profit is a prima facie evidence. It is a prima facie evidence कि आप partners हो. Thus, partnership can be presumed when first there is an agreement to share the profit of business, and last the business is carried on by all or by any of them acting for all. Meaning of mutual agency. Mutual agency refers to the relationship of principal and agents among partners. Example, in case of firm of A, B and C. In first case, when A acts, A is an agent, B and C both are principal. And in second case, when B acts, then B is agent, A and C are principals. And in third case, where C acts, then C is agent and A and B are principal. It means who acts, that person is an agent and rest of others are principals. Types of partner. First one is actual partner. Actual partner is also considered as an active partner. It means a person entering into partnership by contract and taking active part in the conduct of business is called active or actual partner. For all acts done in the ordinary course of business, he acts as an agent of other partner. He has the capacity of binding himself and other partner, vice versa. The third parties of all acts done in the firm's name and in the ordinary course of business. In the event of his retirement, he must give a public notice of his retirement in order to absolve himself of liability for acts of other partners done after his retirement. Second, sleeping partner. Sleeping partner is one who contributes to the capital of a firm and has a share in profit of the firm, but he does not take an active part in the conduct of the business of the firm. The third parties may be unaware of his existence as partner. He is equally liable for all debts of the firm, like an undisclosed principal. Third one is nominal partner. A partner who neither contributes to the capital of the firm nor take a share in the profit and take part in the management of the firm is called nominal partner. Such a partner merely lends his name to the firm and does not have any real interest in the affairs of the firm. Sub-partners. When a partner agrees to the share of his profit derived from the firm with a third person, the third person is known as sub-partner. A sub-partner in no way connected with the firm. He has no right against the firm, nor does he carry any liability for the debts of the firm. Partners in profit only. If it has been agreed among partners that a particular partner shall have a share in the profit only and not be liable for losses, such a partner is known as partner in profit. Towards the third parties, he is liable for all the acts of the firm. Since the liability of partner is joint and several, he may have to contribute the major share in the firm, bears heavy losses, and other partners are not in the position to pay the debts of the firm. Last one is minor as a partner. Kinds of partnership. On the basis of duration and on the basis to the extent of the business. First one is partnership at will. Second is partnership for a fixed period. And on the second basis, particular partnership and general partnership. First, partnership at will. According to section 7 of the Act, it is partnership when no fixed period has been agreed upon for the duration of the partnership and there is no provision made as to determination of the partners. Second, partnership for a fixed period, where a provision is made by a contract for the duration of the partnership. The partnership is called partnership for a fixed period. Particular partnership. A partnership may be organized for a prosecution of a single adventure as well as the conduct of continuous business. Last one is general partnership, where a partnership is constituted with respect to the business in general. It is called a general partnership. Partnership deed. A partnership is formed by an agreement. This agreement may be in written or oral. Though the law does not expressly require that the partnership agreement should be in writing, it is desirable to have it in writing in order to avoid any dispute with regard to the terms of the partnership. The document which contains the term of a partnership as agreed among the partners is called partnership deed. The partnership deed is to be duly stamped as per the Indian Stamped Act and duly signed by all the partners. Content of partnership. A partnership deed may contain any matter related to the regulation of partnership, but all provisions in the deed should be within the limit of Indian Partnership Act 1932. However, a partnership deed should contain the following clauses. First one is nature of business, duration of partnership, name of firm, name and address of all partners, capital, share of partners in profit and loss, nature and place of business, date of commencement of business, bank account firm, books of account, power of partners, retirement and exclusion of partners, death of partner, dissolution of firm, settlement of dispute. These all are included in contents of partnership deed. Now, advantages of partnership firm. First one is easy to form. Like sole proprietorship, partnership business can be formed easily. Without any compulsory legal formalities, it is not necessary to get the firm registered. A simple agreement or partnership deed, either oral or in writing, is sufficient to create a partnership. Availability of large resources. Since two or more partners join hand to start a partnership business, it may be possible to pool together more resources as compared to a sole proprietorship. The partners can contribute more capital, more efforts and more time for the business. Better decisions. The partners are the owner of the business. Each of them has equal right to participate in the management of the business. In case of any conflict, they can sit together to solve the problem. Since all partner participates in the decision-making process, there is less scope for reckless and hasty decisions. Flexibility in operations. A partnership firm is a flexible organization. At any time, the partners can decide to change the size and nature of the business or area of its operation. There is no need to follow any legal procedure. Only the consent of all the partners is required. Disadvantage of partnership firm: unlimited liabilities. All the partners are jointly liable for the debts of the firm. They can share the liability among themselves, or anyone can be asked to pay all the debts, even from his personal properties, depending on the agreement made between the parties. Uncertain life. The partnership firm may know legal existence separate from its partners. It comes to an end with death, insolvency, incapacity, or the retirement of a partner. Future. Any unsatisfied or discontent partner can also give notice at any time for the dissolution of the firm or partnership. No transferability of share. If you are a partner in any firm, you cannot transfer your shares or part of the company to outsiders without the consent of other partners. This creates inconvenience for the partners who wants to leave the firm or sell part of his share to the others. Lack of harmony. In a partnership firm, every partner has an equal right to participate in management. Also, every partner can place his or her opinion or viewpoint before the management regarding any matter or any place. Because of this, sometimes there is a possibility of friction and discontent among the partners. Difference of opinion may lead to the end of the partnership and the business. Limited capital. Since the total number of partners cannot exceed 20, the capital to be raised is always limited. It may not be possible to start a very large business in partnership firm. Implied authority of partner. The word implied authority denotes the authority to bind the firm, which arises by implication of law from the fact of partnership. With the presence of implied authority, a partner binds the firm with any of his acts done in connection with the business. Section 18 lays down that every partner is an agent of the firm for the purpose of the business of the firm. A partner is both a principal as an agent. Every partner embodies the character both of the principal and agent, but a partner is agent only for the business of the firm. Implied authority of partner. Section 19(1) and 22 defines the scope of implied authority of a partner. Section 9(1) lays down that subject to provision of Section 22, the act of a partner which is done to carry on the usual way business of the kind carried on by firm binds the firm. Acts within implied authority. Every partner within the scope of his implied authority may bind the firm by the following acts. First, he may sell goods of the firm, but he cannot sell the immovable property of the firm without the consent of other partner. He may purchase such goods on the credit of the firm as are necessary for carrying on business of the firm. He may engage servants to perform the business of the firm. He can receive payments or the debts due to the firm, but in the case of non-trading, a partner cannot issue a post-dated check. Extension and restriction of partners' implied authority. Section 20 lays down that the implied authority of any partners may be extended or restricted by an agreement between all partners. Section 21 provides that a partner has authority in an emergency to do all such acts for the purpose of protecting the firm from loss as would be done by a person of ordinary prudence in his own case under similar circumstances. Effects of admission by a partner. This is according to Section 23. Admissions made by a partner concerning the affairs of the firm, if made in the ordinary courses of the partnership business, are evidence against the firm. Such admissions made by partners will bind the firm. An admission by a person before he became a partner in the firm is not evidence against the firm. Effect of notice on acting partner. This is according to Section 24. Notice to one partner relating to the business of the firm operating as notice to the firm. The partner of whom such notice is given must be acting in a business at that time. So, a notice to a dormant or sleeping partner would not operate as a notice to the firm. Now, there are some questions on the basis of this session. First one is, what are different kinds of partnership, and explain different kinds of implied authority. Thank you. Happy learning. We learning.